everyone. Welcome to the Search Bar podcast. I'm really excited for this episode today. I just want to start off and ask you and put that out there, right? You've probably built a business and you've probably done it with passion, strategy, and hustle. But the one thing you probably haven't thought about is if it's really legally protected. And I think that's something really important to know about. That's why on today's episode, we're diving into the side of entrepreneurship too many founders overlook until it's really too late. Protecting your brand and your team with a proactive legal strategy. Let me introduce myself. I'm your host, Eric Ritter, and joining me is Florida-based trademark and employment law attorney, Ilona Anderson, founder of Carpe Diem Law Firm. Elona brings a powerful mix of legal expertise and entrepreneurial insight with nearly 20 years of experience helping founders secure their intellectual property, comply with employment laws, and build legally sound businesses. Ilona, thank you so much for joining us today.
Thank you so much for having me, Eric. I'm very excited to be here.
Yeah, I know that the viewers, the listeners are going to get so much out of the conversation. So really want to get in there because I don't want entrepreneurs or founders or owners to have to deal with any legal headaches. But make sure if you're here at the podcast, make sure you stick around for Ilona's 5-step legal readiness checklist as an easy way to assess your business if it's protected or not, or maybe at risk. And we'll get into that at the end. So let's get started here. I want to talk about trademarking and brand protection. It was something that was kind of new to me. It's something that I was actually asked and kind of got it going in my mind, Ilona, is I self-brand myself as the SEO sommelier, right? And someone's like, did you ever think about trademarking that? And I'm like, no, why would I worry about that? So would love to kind of pick your brain on that. If you're just getting started, what are those first steps that they should take to make sure their brand is protected?
Yeah, so trademarks are something that's often off of the founder's radar, especially early on, because they think, well, I'll worry about intellectual property protection when I'm bigger. But really the right time to trademark your brand is before you fall in love with it. Because the first step in trademarking a brand is doing a comprehensive search to make sure the brand is even available. I can't tell you how many heartbroken founders I've spoken with over and over again who ran their business for a number of years. Then at some point, they decided to organize themselves and get proper intellectual property protection. They came to me to do a trademark. I would do a comprehensive search, and it turns out that there are conflicts and their name is actually not available, which would mean that, they could operate without a trademark and potentially receive a cease and desist letter, or not having that asset in their business, right? Or they would have to rebrand. And the average cost of rebranding is about $30,000. We have hard costs, and then there's also the cost of just, lost brand loyalty, right? And customer confusion. And then the average cost of defending yourself in an infringement lawsuit is in the 6 figures. So a little bit of preventative lawyering on the front end really goes a long way to make sure that the brand you are looking to launch and promote and associate yourself with actually can be legally yours.
Wow, yeah, such good points there. And as a marketer, near and dear to my heart is the rebranding, right? That kind of almost gave me a little bit of anxiety there thinking about that. You have one brand, then all of a sudden you're like, oh, we can't use that name anymore. We can't use the colors, whatever that might be. And you just think about, everything that goes into that. That's redoing your website.
And sometimes it could be a bunch of product, right? Like if you put your brand name on a bunch of product that has already been manufactured, potentially you have to scrap all of that. And that's a lot of sunk costs.
Yeah. So get that search done early, it sounds like, to make sure that trademark is available if you want to keep that business going long term is what it sounds like.
Yeah, absolutely. And then the other comment I wanted to make regarding the search is there's a big misconception that if you can just do a Google search or even a basic USPTO search looking for exact matches and there's no exact match, that means you're in the clear. In reality, the USPTO, US Patent and Trademark Office, evaluates brand names from the perspective of customer confusion. What is likely to cause customer confusion? So brand names don't have to be identical to pose a likelihood of confusion. So when an attorney, for example, does a comprehensive search, we look at singular and plural. We look at different spelling variations. A lot of people think that you can come up with a cutesy spelling and avoid a potential infringement, and that it doesn't work that way. We'll look at phonetic variations. We'll look at similar connotations if the words are different. We'll look at different word combinations, foreign translations. So it goes way above and beyond what just a cursory Google or USPTO search would do. And in connection with that, if we find any conflicts, then we also evaluate, well, are those conflicts in the related category of goods and services? Because when you apply for a trademark, you can own a trademark in perpetuity as long as you're continuing to use that brand name in commerce. However, you don't own that name in the abstract. You own it in connection with specific goods and services. So if we spot any conflicts, then we can see, well, are those other goods and services related? This is why we can have, for example, Delta Faucets and Delta Airlines. They're both Delta, they're both trademarked, but there's no likelihood of confusion because the goods and services are so distinctly different.
That's such a great example there. With Delta Faucets, Delta Airlines. I have a question concerning the process, right? So you talked about kind of doing the research, figuring out if you're in the clear or not, and a lot of nuances there. But how long does the process actually take, right? So if I say, hey, I want to trademark my name, you start doing the search, how long does it take until I can actually finally put that little R for the registered trademark next to my logo or my name?
Sure. So the USPTO is pretty backed up with trademark applications. The attorney's part can be done pretty quickly. I usually turn around a comprehensive search and provide a legal opinion letter providing risks, usually within 72 hours. And then I recommend to my clients, although there's no hard and fast rule, but I recommend to my clients that then if they're ready to proceed with a trademark application, we do it within a week or so, because there's always the risk that somebody might swoop in during that time and apply for something similar, so the search results kind of can go stale the longer you wait. But once it's submitted to the USPTO, it takes about 8 to 10 months before a USPTO examining attorney even gets to look at your application. And from that point on, they will either issue a notice of allowance, or they will issue what's called an office action, which means that there's some kind of substantive or procedural issue that we need to address, either by providing additional information or making some kind of legal argument. So all in all, the registration process takes about a year. And this is another reason why it's so prudent to apply early, because as entrepreneurs, we don't sit around, and just wait for a decision from the USPTO, right? We spend that time building our brand, putting money into our brand, creating our offerings, creating our product, selling things. And so, and that's why that comprehensive search is so important, because it gives you reasonable, and I mean, even though there's never any guarantees, right? And examining attorneys are humans and they use a certain amount of discretion, but you can have reasonable amount of certainty as to, more likely than not, your application is going to get approved. Or the attorney, after conducting a comprehensive search, can tell you, okay, no, there's clear conflicts. We don't advise that you proceed with registration. Or maybe it's not even a conflict. Maybe it's not the kind of name that can even be trademarked, because there's different types of trademarks. And the USPTO does not like trademarks that are, for example, just merely descriptive. You can't trademark New York pizza or beautiful nails for a nail salon, something that merely describes your business, because you can't exclude others from using those terms. Right. So part of working with an attorney is not just going to the USPTO.gov and filling out the form, right? It's knowing what can and cannot be trademarked and what the risks are with proceeding with a given application. However, the good thing is that as soon as you submit your application, you have that priority date. So if somebody submits an application for the same or similar brand a week later, then they have a later priority date. And so you are essentially ahead of them. So the answer is always the sooner the better. And another thing I wanted to point out is that you don't even have to be in business yet to apply for a trademark. There's two types of trademark applications. There is a 1A, which means that you are already selling your goods in commerce or services. And there is a 1B, which means intend to sell or intend to use, which means within reasonable time, you plan to launch your business. And so since the review process takes, up to a year, that gives you time to actually launch your business in the meantime, but you already know that more likely than not, it's going to get approved because you're working with an attorney who's done a comprehensive search. And if you're not ready to launch yet, once you receive that notice of approval, then you can submit up to 5 extensions to the USPTO until you have to actually show that you are using your brand in commerce.
Wow, so much great advice, right? So I love the options there, as you pointed out, right? You don't even need to be using it yet, but the key is to get started as soon as possible. And this is the search bar. So like so many things, it starts with a search, right? So every time I hear comprehensive search, it makes me smile because to me, search is the beginning of a lot of things, whether it's the customer journey, people asking questions, from a marketing standpoint, and just getting to the bottom, getting an answer, right? Same thing when you're going after a trademark, looking to register it, you need to start an in-depth search. And this isn't something, like you said, isn't something you just go to Google or to a search engine or ask ChatGPT. You need a legal professional who understands actually the law behind everything when they're doing that search to kick everything off. So thank you for sharing all that.
Yeah, absolutely. I mean, there's so many trademark services out there that advertise $99 trademark or $199 trademark, but they're just document preparation services. They don't do comprehensive searches. They're usually not run by lawyers. They don't give you a risk assessment. And if you receive an office action indicating a refusal, they usually just leave you hanging, and then it's up to you to either pay them more or hire an attorney to dispute that refusal.
Yeah, so might as well get someone knowledgeable who can make sure you're getting a trademark that's going to stick, right? And that's going to actually be, I don't know if the right term's enforceable, but something that you won't have a problem with down the road because you own it legally.
Yeah, absolutely. And just to answer your question about the Circle R, just to come back with it.
Yes.
So you can't use the Circle R until your registration has been approved. However, you can use TM in the meantime. So,
okay.
So
good
TM,
to know. Good to know.
Staking that flag, you just claim it, it's mine, hands off. But the R, that's what makes it official.
Absolutely. Okay. Well, everybody stay tuned. Hopefully sometime soon you'll see that R after SEO sommelier. So I'll be excited when that happens. Another thing, just to kind of pivot a little bit here, Ilona, was something else that's important for founders, for entrepreneurs as they're getting started, and that's hiring, compliance, and contracts, right? All kind of that boring, let's say, legal stuff that, if you're a founder, you're not sure, you're a visionary, right? You don't really want to get bothered by those kind of things. But I'm sure there's a lot of mistakes that can be made there. So I'm curious if you have any examples that you could share, maybe, the biggest legal mistakes that business owners or entrepreneurs can make when they're actually hiring someone.
Oh my God, so many. I'll give you, where to start? I'll give you the top ones that are all related to wage and hour practices. So a big mistake is not paying somebody their minimum wage or overtime. And overtime kicks in when somebody works in excess of 40 hours per week. So if a non-exempt employee is working more than 40 hours a week, they have to be compensated at the rate of time and a half their regular rate. So I firmly believe that most business owners want to comply with employment laws and that are well-meaning. So there's a lot of landmines in employment law, and there's a lot of violations that happen unintentionally, despite good intentions. But as an employment attorney, just to backtrack for a second. So
Yeah,
I
you're
firmly
good.
believe that most business owners are well-meaning and they don't intend to violate the law. They intend to fully comply with the law. But as an employment attorney, especially an attorney who represented a fair number of employees, I've seen it all. And I've seen a lot of intentional violations. And I think a lot of those intentional violations happen because employers underestimate the consequences of not paying somebody their minimum wage or overtime. Because usually they think, well, these are not large amounts. If I get caught, I'll deal with it then. But chances are I don't get caught. So they think it's worth it, right? They do, in their mind, they do risk benefit analysis and they think it's worth it. In reality, there's a law called Fair Labor Standards Act. It's federal law that guarantees payment of minimum wages and overtime. The penalties for violating the FLSA are very severe and can add up very quickly for employers. Let's say your employee sues you for unpaid minimum or overtime wages. Let's say they're only able to prove a portion of their claim. They sued you for X amount. They only were able to prove a portion of their claim, but there's still a prevailing party in the lawsuit. So whatever amount of damages, whatever amount of unpaid wages they're entitled to, by law, almost automatically that amount is doubled. I mean, it's doubled when the violation is proven to be willful, but I would say I don't think I've ever had a case where I wasn't able to prove a willful violation. So it's generally very easy to prove. On top of that, you have to defend yourself. A corporation has to defend yourself with an attorney. You can't be pro se. A corporation cannot defend itself without an attorney, right? So you're hiring an attorney to defend yourself in court, usually in federal court. And on top of that, there's a fee shifting provision under the FLSA, which means that the losing employer has to pay the prevailing employee's attorney's fees. So, you think, okay, well, what's a few hours of unpaid overtime here and there? But then you get slammed with a lawsuit. You have to pay your attorney. You have to pay double the amount what your employee is entitled to. Plus, you have to pay your employee's attorney's fees. So it can add up very quickly, and it's just not worth it. The second thing I wanted to mention, just don't do it.
That's just crazy. Yeah, right. I mean, so what that reminds me of is almost like a little bit drunk driving. You're like, hey, it's not going to be a big deal. I've only had 2 drinks, and you get in the car, you get pulled over. It's not just that you get pulled over. You're going to go to jail. You're going to lose your license. You're going to have to pay all these fees and everything else. So it's just one little decision that can really bloom into a much bigger issue. Just because you thought, oh, I don't need to pay people here and there a little bit, can have really big consequences.
Exactly. Really good analogy, and presumably if you're not paying one worker, you're probably not paying all your other workers, right? So it can very quickly turn into a collective action, which is the equivalent of a class action under the FLSA, or it can result in a Department of Labor investigation and have fines and, so like I said, just not worth it. The second common issue that we see all the time is misclassification. And that's usually done for the purpose of avoiding paying somebody minimum wage or overtime. So misclassification usually comes in 2 forms. Excuse me. Misclassification usually comes in 2 forms. So misclassifying an employee as an independent contractor, or misclassifying a non-exempt employee as a non-exempt employee. So the exempt versus non-exempt, usually employees that are exempt from overtime are managers, administrators, highly compensated employees. But what I often see in my career is that the label of a manager or the label of an administrator would be slapped on an employee, whereas their 80% of their normal duty is like stocking shelves, and of course the courts look beyond the labels. They apply what's called the primary duties test and see if you're truly entitled to be exempt from overtime. You can't just call somebody a manager, have them do menial work, have them work 60 hours a week and not pay them overtime. And then the other type of misclassification that I think causes the most amount of confusion among business owners is employee versus independent contractor. So what a lot of employers think is that if I pay somebody with a 1099, if I have them sign an independent contractor agreement, if they want to be classified as an independent contractor, then they're an independent contractor. But the law looks at what's called an economic realities test. So it looks, again, beyond the labels, beyond the tax form, beyond the agreements. It looks what is really the economic reality of the relationship between the worker and the employer. And there's a 6-factor test that was recently updated by the Department of Labor. And it asks such questions as the amount of control that's exercised over the worker, the permanency of the relationship, whether the worker can control how, when, and where they work, whether the worker provides their own tools or their tools are provided to them, whether the worker is economically dependent on the employer or they can go freelance and work with others and have other means of making money and service other customers. So none of the factors is dispositive in and of itself, and the courts look at the totality of the circumstances. But generally, the more control and the more dependent the worker is on the employer, the more likely that this is the employer-employee relationship. The more freedom there is, then the more likely it is somebody who is an independent contractor.
That's so important, right? And I just want to flag that here because especially as a startup, as an entrepreneur, it's so difficult to know, like, when should someone be an employee? When are they an independent contractor? You're hiring people off Upwork, and I've seen that plenty of times. You hire someone off Upwork, they do a couple hours here and there. Then all of a sudden now they're working 40 hours for you, so when should that conversation, or when should that really be addressed? I guess the distinction be made that someone is an employee, like you said. You gave some great guidelines there. But if I'm a startup and I just have someone working a couple hours, then they level up and now they're working 40 hours. Do I need to turn them into a full-time employer, or can they just always be an independent contractor? Or how does that work?
Yeah. So when you're hiring somebody on Upwork or through an agency, it usually is not an issue because the agency regulates the relationship, and technically they're not your employee. You're the client, and they're free to provide services to others. But sometimes people take a worker off Upwork and said, "Okay, well, come work for me full time. You've done such a great job," and that's when you really start looking at the economic realities test. What I can do is, for anybody listening to this podcast, if you want to send me an email, I can share a guide that I prepared for employers that distinguishes employees from independent contractors, that has examples, explanations, and kind of step-by-step process to help guide founders, because it can be a very, very confusing issue, and you have to look at it really in a case-by-case scenario. But I would say, usually business owners want to hire somebody as an independent contractor, right? Because you don't have to worry about taxes, you don't have to worry about overtime, you don't have to worry about benefits, this and that. It's convenient. I get it. But if they become your full-time dedicated person who's integral to your business, and you tell them when to work and where to work and how to work, and they have to comply with your systems and policies and procedures, potentially wear your uniform, and you provide them with a laptop or equipment, etc., they're an employee, so you need them to treat them as an employee. So
no, that's great. And that's such a generous offer. So just want to underline that, and I'll mention at the end, is that people can reach out to you, and you have a guide that can help people understand a little bit more independent contractor versus employee.
Yes.
Awesome. One final thing when it kind of comes to the hiring and everything there is, I'm curious if there's any absolute must-have contracts or maybe even policies that someone should have in place, whether they're just getting started, or it's their 15th or 50th hire. What should they have in place there?
Okay. So it's very important to have solid employment agreements, or at least offer letters outlining the terms, and independent contractor agreements. And next, I would say employee handbook. Employee handbooks are more than just a formality, right? You need to clearly communicate to your employees what the policies are, what the procedures are, what kind of leave they're entitled to, not only because first of all, those policies have to be compliant with the law, and also employees obviously thrive when there's clarity. But in addition to that, to make sure that any policies and procedures are applied uniformly, because if not, if you're enforcing a policy in connection with one employee but not enforcing in connection with another employee, you could potentially be accused of and sued for discrimination, depending on the circumstances. So having uniform policies and also applying them uniformly is definitely very important to prevent any possible discrimination lawsuits. Also, confidentiality agreements, non-disclosure agreements are extremely important. In any independent contractor agreement, you want to make sure you have a work for hire provision when it comes to any intellectual property, so that your contractor for any intellectual property they create on your behalf, so that's understood that you own the rights to it and not the contractor who created it. And one thing I want to mention about contracts is, so many disputes arise from handshake deals, and handshake deals go south all the time. But most of the time, they don't go south because of fraud. They go south because of misunderstanding or misalignment of intentions. So a lot of people tell me, well, I don't want to spend money on a contract because I trust this person. I know they're never going to stab me in the back. They're never, we have a great relationship. But a purpose of the contract goes beyond just the need to avoid fraud. When you make that handshake deal, you'll understand, both of your intentions may be entirely pure, but you have one understanding of what the terms of the deal are, and the other person may have a very different understanding, or maybe there's aspects that you haven't even talked about, or maybe there's things based on an assumption. So most disputes arise because there is no meeting of the minds, because the parties haven't bothered to sit down and put things down in writing and talk about all of the other terms that should be part of the contract. So just because you trust somebody doesn't mean that you shouldn't have a contract.
Couldn't agree more, right? There's a clear line, should be a clear line between friendship and business, right? Mm-hmm. Just like, what is it? Goodfellas, they say, it's not personal, it's business, right? And you need to really stick to that, because to your point, it's not because people are malicious or they want to, but things just happen in business, and kind of having it written out, I think is very important. So, thank you for pointing that out. Yeah.
Yeah.
So if after this time, people don't realize how important it is to have a lawyer, have an attorney, kind of help them out, I think we need to dig into that a little bit more. So there's certain times when you really should call a lawyer no matter what. And I'm curious, Ilona, if there are some early red flags, maybe that a business might be vulnerable and really need to be in touch, and maybe call you or call a lawyer to help them out.
Sure. I would say one of the situations is when you're scaling fast without proper legal foundation, because there's certain laws that become applicable when you meet certain thresholds in terms of the number of employees or the amount of revenue. For example, to fall under the jurisdiction of Title VII and most of the federal anti-discrimination laws, you have to have 15 or more employees. Although different states have different requirements. So just because this is the federal requirement, talk to an attorney in your state, there could be stricter requirements in your state. Under the Fair Labor Standards Act, the law that we talked about that enforces the wage and hour practices and guarantees payment of minimum wages and overtime, the threshold is generally for the employer is the covered employers, that the employers who generate at least $500,000 in gross sales. Now, there's some exceptions. There's always exceptions under the law, but that's the general rule. To be covered by the Family and Medical Leave Act, you have to have at least 50 employees, and there's additional requirements. So as you're scaling, things that you thought you didn't need to worry about on the front end, you start needing to worry about as your business grows and you meet certain thresholds. Another red flag, I would say, not having insurance. So many business owners think, well, I have an LLC or I'm incorporated. Why do I need insurance? Isn't the whole point of the corporate protection or the LLC shield is to shield me of that liability, right?
Mm-hmm.
But if you get a judgment that wipes out your entire assets, it can drive you into bankruptcy. And you don't even have to have done anything wrong as the business owner. Your employee might have done something. If your employee makes a work-related delivery and then hits and kills somebody, you're going to get a judgment that could potentially put you out of business. If you have a rogue employee, let's say, who sexually harasses a subordinate, if you don't have the proper employment EPLI insurance, employment practices liability insurance, that could also potentially drive you to bankruptcy or put you out of business. And there's also certain laws, there's under certain circumstances, corporate veil can be pierced to where you can become personally liable. And there's certain laws under which you can be sued individually, including that law that we talked about, the Fair Labor Standards Act. An employee can bring a lawsuit against the corporate employer and the individual employer. So you can be individually liable. So if you have insurance in place, it protects you. It provides you not only counsel that can defend in a lawsuit, right? The insurance company's counsel, but it also has makes money available for you to pay judgment if something happens, and things happen all the time, especially if you have employees.
Got it. Yeah. So if you're scaling quickly, if you don't have insurance, those are great things. And if you're as confused as I am by the FLSA, I think it's time to reach out to an attorney right there. And just wanted to get to know a little bit more about your law firm, Ilona, the Carpe Diem law firm. And really, it seems like, you kind of focus in and you're aligned with entrepreneurs. And if you could just share a little bit, what makes you so aligned with entrepreneurship and kind of where that comes from.
Sure. So I love working with other entrepreneurs because I'm an entrepreneur myself. Carpe Diem Law Firm is my third venture. I have co-built 2 prior law firms with partners and scaled them to 7 figures and had teams of employees. So I understand entrepreneurial struggles and what entrepreneurs go through. In my prior law firm, I was focused primarily on plaintiff side employment law, so representing employees. And so when I launched Carpe Diem Law Firm, because I wanted to be of service to entrepreneurs, although I still work with employees from time to time, but I've pivoted to mostly provide employment law, compliance services, and defense services to employers. And I believe from having done plaintiff side employment law for 12 years, I have an insider perspective as to why employees sue their employers. And I want to be there for employers on the front end to help prevent those issues, because most of those issues are preventable. Like, I can't stress the importance, whether it's with trademarks or whether it's with employment law, the importance of preventative lawyering, because it's so much less expensive and so much more efficient to just align yourself with an attorney on the front end. It's like with trademarks, right? The analogy I can give is when you're building a house, like, you want to make sure that the land where you're building a house is yours, right? Before you start building a house.
Right.
That's kind of like the value of trademark protection. Before you build that brand, you want to make sure you can actually own it, so you're not inadvertently building somebody else's brand. With employment law compliance, so many issues can be prevented with proper wage and hour audits, with proper contracts, with proper consultations, systems, policies, procedures, just general understanding of employment laws. So I'm there for entrepreneurs to help them prevent those issues, to build a solid foundation. And as an entrepreneur myself, I try to provide advice that's truly practical and not just, theoretical, like in the ideal world, you would have this, and that, because not everything you should have is really practical, right? So I focus on the biggest risk areas and kind of the biggest returns. I
love that you kind of bring your own your own experience and everything that you've done kind of into it, right? Which is almost, in my opinion, a little unique, especially when it comes to attorneys, right? That they're actually doing it themselves. You're an entrepreneur, so you can help with entrepreneurs with all those issues, right? Like if I'm a personal injury attorney, there's only so much actual experience I can have of kind of going through that myself, right? Maybe not the best analogy, but just wanted to point out that kind of having living, eating, breathing the entrepreneurship journey that you are really makes you an expert in it as well, which I think is really cool.
Yeah, thank you.
Yeah, so let's get into one of my favorite parts of the podcast, which is the checklist at the end. For everyone, I hope you've really been enjoying the episode. So many great nuggets from Ilona, and want to go over the legal readiness checklist here, which we'll post in the show notes as well. And it's really just a way for us to go over and make sure, if you're an entrepreneur, what are those 5 key protections every entrepreneur, every business really should have, and making sure that you have that legal readiness checklist. So I'll get started here. We have 5 different key points. Number 1, which we started the episode with, is trademark your brand, right? Like Ilona said, better sooner than later, right? Get it started as soon as you can.
Yeah, and really understand that your brand, your registered trademark, is an asset. It increases the value of your business. It grows with your business. And so as you start developing more brands or products, et cetera, you can build your intellectual property portfolio. And by the way, that goes for patents and copyrights as well. My focus is trademarks, but there's other intellectual property that you should be focusing as well, especially if you're inventing things or creating works of art. So yes, agreed. The sooner you can do it, the better, because again, it goes to preventative steps. If you find out early on that you can't even move forward with a brand, then you want to have an opportunity to rebrand early on before it has massive impact on your business, or before you receive a cease and desist letter or get served with an infringement lawsuit.
Absolutely. That's really so important. That's why it's number 1, right? That's the foundation of everything, making sure you own your brand. You own kind of everything that goes along with that. Number 2 is the contract, right? So really having solid contracts, whether that's for your team members on the employment side, the employees, but also with your clients, right? If you're delivering services, a handshake deal isn't going to do it, right? You need to have that contract in place, and couldn't agree more, Ilona. So fantastic point there.
Yeah, and I would also add, nowadays, so many people resort to DIY contracts. We have ChatGPT, we have Google, there's so many templates floating all over the internet. So people end up putting together these Frankenstein contracts, which, are better than not having one. But oftentimes, the parties don't actually understand all of the terms of the contract. And the point of the contract is to have the meeting of the mind, to have negotiated terms, right? That both parties agreed on and fully understand. So, which is why there's, again, value of working with an attorney who can create a customized contract for you, for your business, and explain all of the term, explain all of the implications, so you don't end up with some Frankenstein document that the parties don't understand and that may or may not even be enforceable in your jurisdiction.
Yeah, and you brought up a good point there, just real quick, is the jurisdiction, right? There's so many different levels, whether, it's the county, the state, the federal level, is you really want to work with someone who has the expertise in where you're doing business, right? We didn't even get into, if you're, doing business in, one state and your clients are somewhere else, your clients are internationally. There's so many complications there that you want to make sure that you have something in place that is solid and is going to keep you protected.
Yeah, absolutely. Like, let's say if you have employees across different states, you have to comply with employment laws in each state where your employees are located.
Yeah. Especially in today's world, right? We have so many virtual employees, right? Where you have virtual offices and they're sitting in California or who knows where. And, we all know famously, California has some very strict compliance laws there. So, those are things to
employee friendly. Mm-hmm. Yeah.
So those are things to be aware of, if you have a company and you have employees around the country as well. Which brings us to point number 3, which is employment compliance, right? So making sure that you are compliant with everything for your employee. Is it an independent contractor? Is it a full-time employee? Are you paying the state taxes that you need to from wherever they're sitting? There's a lot of different compliance issues that come in. And especially, Ilona, like you said, as you're growing or scaling at different sizes, different compliance is needed.
Yeah. And like I said, there's so many landmines there. Okay, what is the applicable minimum wage? At what point do I pay overtime? A lot of employers think, well, if over the course of the year, the average number of hours worked is 40 or less, then I don't have to pay overtime because it all averages out. That's not how it works with overtime, because overtime is calculated for any given week. If in one week your employee works 50 hours, but next week your employee works 20 hours, that extra 10 hours from week 1 does not carry over. You're not okay. You still have to pay for that week at time and a half. Exemptions. At what point do exemptions apply? Or classifications, employee versus independent contractor, or anti-discrimination policies. Again, there's so many things that can prevent lawsuits on the front end if you align yourself with the right legal counsel.
That's so important, right? Which brings me to the next point here, which is having a legal partner on speed dial, right? So having someone who you can ask questions to, someone who you can bring in when you have questions, I think is important, because you're gonna hire someone. We talked about it before here a couple minutes ago. Hire someone in a different state. You might have some questions there. Or, hey, I brought in someone, I thought they were independent contractor, but they're actually might need to be an employee. So you need to have that legal partner that you can bounce those questions off of.
Absolutely. I've had multiple founders tell me that after talking to me, they can sleep well at night, and that just wouldn't apply applies to many attorneys, because you don't want to wait until you have a problem to call a lawyer. Like an attorney should be your trusted partner, your trusted advisor, not your emergency contact. So sure, obviously call us if there's an emergency and we'll come and fix it, but it's just so much easier and cheaper to prevent issues than to fix them.
Just like anything else in life, right? Yeah. That maintenance is so important. Get your oil changed when the car tells you to. Don't wait until you have to replace the car, replace the engine, right?
Yeah, absolutely.
So part of that, I think, and the final point here on the checklist is an annual legal review, kind of checking in, especially if you're, an entrepreneur, you're a startup and you're growing really quickly. I think that's really important. But Ilona, if you could just fill the listeners in a little bit more, what should be done in this annual legal review?
Sure. As business grows, the needs change, right? Over the course of the year, you might have added additional intellectual property that needs protection. Over the course of the year, you may have added or shuffled around your employees and shuffled their responsibilities. And so an employment attorney can come in and do a wage and hour audit to make sure that you have proper employment agreements, proper job descriptions, that you have proper classifications, that everybody's getting paid their minimum wage, that everybody's getting paid their overtime, that you have uniform application of policies. Nothing stays stagnant. And like with everything in line, the law of entropy applies, right? Everything moves from order to chaos unless you put, an energy injection, an opposite force to control the chaos and bring things back into order. So whether it happens like in our own businesses, right? Like think about the moment we create systems and policies, procedures, almost immediately they start decaying, right? Because you start changing how you do things and you change this and that, and they become obsolete if you don't have cadence to update them. Same goes for legal things. Legal advice that was given to you a year ago on any particular issue could become stale because your circumstances might have changed or the laws might have changed.
Absolutely. That's so true. And thank you so much for kind of filling everyone in there. Because we both know, everyone here probably knows that every founder, entrepreneur especially, starts with vision, but really only the smart ones, right? Build protection into that vision from day one, from the beginning. And those are going to be the ones that are successful in the long run and the long term. So if you're launching your first product or scaling a team, your legal strategy just needs to grow with you, right? And so we gave some great nuggets here. So a huge thank you to Ilona Anderson for dropping all these gems in today's episode. Visit the carpediemlawfirm.com to connect with Ilona and book a legal strategy session today. Or if you have any questions there, Ilona, it sounds like you do have some guides that you can share with everyone. By the way, I love the website, carpediemlawfirm.com. So easy to remember. So congrats on getting such a great domain name there, the URL.
Thank you. Thank you very much. It means a lot coming from the SEO sommelier.
Of course. No, absolutely. I know a good website when I see one. And also, if you do want to get to know Ilona a little bit better, do check out the website. She has great content on there about her law firm, her practice areas, and herself even a little bit, which I really think is great that people get to know you a little bit better there on the website.
There's always a human behind the lawyer, right?
Absolutely. And that's what we're humans, right? You want to do business. It's two humans doing business. It's not two corporations or two companies. So I really, really enjoy the website. So definitely recommend everyone to go check it out. And if this episode helped you think about your business in a more protected way, I know it did for me, share it with a fellow founder. It might just save them a headache down the road. And I'm willing to say it not just might save them a headache, it will save them a headache down the road. Thanks for joining the search bar. Now go hit record and start building your brand one episode at a time. For today's episode, I'm giving a wine recommendation, as I always do for this conversation. I'm recommending an Argentinian Malbec. I love the Malbecs from Argentina, especially I think a 2018, 2019 is a really good year there. So that's my recommendation, because I think just like a good legal strategy, a Malbec is bold and balanced and something that evolves with time and enhances every decision you make. So Ilona, thank you so much for being such a fantastic guest. I know people are going to get so much value out of this. So thank you for taking some time out of your day and chatting with me here.
My pleasure. And I can't wait till 5 p.m. to have some Argentinian Malbec.
Yes, please enjoy it. Cheers to you and everyone listening. Thank you.
Thank you so much, Eric. A pleasure being on your podcast.